Hello, everybody. Hello, Lisette Panette number 1. So close. Hello, Spider-Man. Hello, Nana Laura. Hello, Rocky Lennon. Hello, C-Rex. Hey, Shane. Good to see you. Hello, Sir Philip. And hello there. Oops. Hello there, CE. Hello, Auntie M. It's so good to see you guys. Hello, Barbie. Great to have you. And here is our beautiful Ava. Right on cue. Thank you. I love it. I love blues. Hi, baby girl. A box came today. A box. A box. We're going to open it because I have a feeling. I have a feeling that it is for our beautiful, wonderful, special pop-up. And if it is, well, she deserves it. Don't you, pups? Don't you, baby girl? Okay, this doesn't look like dog treats. I thought it was dog treats. I'm sorry, Ava. I'm sorry, Ava. I really thought it was dog treats, Ava. It says Bon Voyage. Okay. So my daughter is going to college very soon. Like end of this month soon. Couple weeks away soon. And this is a set of sheets for her dorm bed. Oh my gosh. Thank you so much. I am going to have to run and give them to her before, like once I put the clips on. I'm going to have to tie this back up. I'm not going to get that tissue paper back on it, but it's in a gift bag. So thank you. Oh my gosh, she's going to be so happy. She's going to love them. Oh, it doesn't even feel real yet. I'm sorry, Ava. I thought they were treats. Maybe next time. Congratulations. Hello, Janet. So good to see you. Congratulations. Okay. I'll get your bag out. Sorry, she's like, just because that wasn't treats doesn't mean you get to skip them, Mom. Yes, baby girl. There you go. Hello, Patrick B. I'm sorry. I didn't know. I was expecting them to be treats. She'll forgive me, I promise. Right? You'll forgive me too, won't you? As long as you keep feeding me, Mom. Oh my gosh, you guys. And I saw Kiaora. Is Yvonne in here? Oh, there she is. Hi, sweetie. I saw somebody say Kiaora, and I knew exactly who they were singing it to. There, Ava, there's your 3. So what we have for tonight, oh my gosh. So I've got a fun mix of Judge Satterfield, Judge Boyd, Judge Washington. I feel like there's more than that. But that's enough to start out, right? Right? That's enough to get us going, at least. Oh my gosh. Oh, I'm so happy for you. That's amazing. Congratulations. My baby girl was 8 pounds, 6 ounces. She was a tiny, oh no, I'm sorry, 6 pounds, 8 ounces. She was a tiny little thing. Absolutely tiny. And she's still a tiny little thing. Yeah, we can. We can. I mean, it's a lot, but we can. We'll see how awake I am, you know. That matters. Y'all, the last few times I've streamed, y'all have begged me to go later and later, and you know, that 4-hour mark, and I'm falling asleep in between dockets. It's all right though. It's all right. I do it because I love you guys. Y'all make me so happy. Yeah, Billy is still outside. He's being a butthead. He's not coming in. He's not even coming to the door. So, yeah. Hi, Sherry Bingo. You're just in time, love. I'm just getting ready to start. I'm gonna start the clip, and then I'm gonna run and take my beautiful daughter her graduation going away sheets. Oh, don't make it real. Don't make it real. And then I'm going to check and see if Billy's ready to come back inside yet. Oh, let's see. Who do we start with? Let's start with Judge Washington.
Spirit Ford Incorporated versus Gerardo Alcantara.
Good afternoon, Your Honor. Michelle Harrell, appearing for Spirit Ford.
Case number 22C3359. Good afternoon.
I'm right here, Your Honor.
Please state your name.
Gerardo Alcala Rivera.
Now, am I wrong? Or is this person continuously saying, Dear Honor? Dear Honor.
Thank you. All right, we're here today. Is this on the motion for entry of default and granting of a default judgment against defendant Gerardo Alcalca Rivera?
Yes, Your Honor. Yes, it's our motion. Your Honor, we are seeking a default judgment in the amount due on the vehicle. This was a vehicle purchase. Mr. Rivera signed the purchase agreement but failed to pay. And he has no defense. He did not answer the second amended complaint. He did not answer requests for admissions and other discovery. We filed and served this motion on him. And so today we're asking for a default judgment in the amount due on the purchase agreement, which is $24,344.53. And that's what we're asking for today, Your Honor.
Mr. Alcalca Rivera, you're here today. Did you get served with these documents and failed to respond, sir?
Yes, dear honor, but my health has decreased. I've been in medical for the last,
What'd you say?
my health has declined
I see. Okay.
and I didn't have time. I've been trying to save my health. It was going down. I can't do nothing. I'm a bed rest at the moment.
Okay. So you're requesting some additional time to be able to respond?
Yes,
Well, why didn't you answer the complaint when it was filed initially?
because I have to take some time out from work. I almost lost one of my limbs, and I've been in excruciating pain.
Okay.
And I've been on a lot of medications as well. And they told me to take it easy. My doctor advised me to take it easy.
Thank you. So in this particular case, Mr. Alcalca Rivera did file an answer to the initial amended complaint, but did not assert any affirmative defenses. But you're indicating that when you that the first amended complaint on July 27th?
Yes, Your Honor, there was a second amended complaint filed and also the discovery requests, which included requests for admissions, were not responded to. And beyond that, there just is no defense. I'm sympathetic to Mr. Rivera's situation. But this case has been pending for 2 years and there's just no defense to not paying the agreement and breaching the contract. So we request the judgment, Your Honor, today.
Well, you know, the fact that this matter has been going on all this time is not Mr. Alcalca Rivera's decision all alone. There were additional defendants who've been brought in this matter, and the attorneys have requested additional time with respect to those particular issues, and the court's granted that time, correct?
Correct, Your Honor. Yes.
And so the fact that there may be a defense is not something that's done through default. Typically, it's done through a motion for summary disposition. I think the default was initially being filed. Well, actually, he showed up. I think he didn't show up initially on the last hearing date, June 20th, but then he actually showed up and was present. Discovery has concluded in this matter?
Yes, Your Honor.
Mr. Alcalca Rivera, when you showed up initially in this particular case, you had indicated that you weren't the purchaser of the vehicle, but you did sign the actual agreement, correct?
Yes,
Your default in this case asked for a default based on failure to respond to requests to admits.
Yes, Your Honor.
Those were sent back on January 12th of 2024 to Mr. Alcalca Rivera.
yes, dear honor.
When did your health issue become an issue, Sir?
It's been since last year. It started last year, but it keeps coming. It's going and leaving, and then now it got worse. I've been trying to save my limb for this last year and a half. They don't know what's going on with my health. They just told me to take it easy.
Mr. Alcalca Rivera, part of the reason why this is such an issue today is because you don't have an attorney who can advise you regarding the matters that are before the court. And you were served with those requests to admits back on January 24th. When you don't respond to those, then what can happen is you can automatically receive a default, meaning that you lose this case. And part of those requests to admits indicate that you purchased the vehicle for third parties from other dealerships before and defaulted upon those loans as well. And that you delivered the vehicle to Lindsay and allowed him to take possession of it and use it and conceal the vehicle, and that you perpetrated a fraud upon Spirit Ford, and you didn't respond.
It was not a fraud. They offered me some money, Dear Honor, to sign that contract. And they offered me $500.
Well, that's a fraud, sir. That is the fraud.
But no, I did it with a good heart. I didn't know
That's not a good heart. All right. I am very sympathetic to the fact that you are having medical issues at this point, but the reality is that I don't see how you're ever going to get past this issue in the first place. The fact of the matter is that you may deny some of the admissions in this case, even if I give you time to do so, but you signed the contract. Now, whether it was perpetrated as a fraud or not doesn't negate the fact that it makes you responsible for the contract since you signed it. So
okay, Dear Honor.
Based on that, I am going to grant the motion for default. You need to submit a document, a default judgment to that effect, Counselor.
Thank you, Your Honor. Thank you. Mr. Rivera, I hope your health improves. Thank you.
Default judgment is granted in this case in the amount requested. The judgment needs to be submitted to this court within 7 days. I would suggest you submit it under the 7-day rule or submit it today, and I'll sign it today, but otherwise it needs to be submitted on a 7-day order.
Yes, Your Honor. It's attached as Exhibit 5 to our motion. I don't know if you have a copy.
Yeah,
I'm
it's all
happy.
tagged down. It's all tagged down in the file. Give me one moment.
Okay.
All right, I'm signing the order in this case in the amount of $24,344.53.
Thank you, Your Honor.
Thank you. You're all set.
Now, whether it was someone taking advantage of Mr. Rivera and, using their good heart against them, or whether it was Mr. Rivera, being complicit in it, a fraud's a fraud. And one way or another, he perpetrated a fraud. And if having to pay that money back is the only consequence, he'll consider himself lucky, I'm sure.
Thank you.
You have a good day.
Thank you. The court will call the matter of AAA Insurance Company versus Nicole Franklin, case number 03C1736.
Good afternoon, Your Honor. May it please the court, Keith Cox of Winters and Associates on behalf of the plaintiff, P59146.
Good afternoon. Ms. Franklin, if you could unmute and state your name.
Good afternoon, Judge. Nicole Franklin.
Good afternoon. All right, we're here on a objection to the garnishment in this particular case. So Ms. Franklin is indicating that the judgment was brought against her back in 2003, and she believes she paid this judgment.
May I speak, Your Honor, or wait? Yes. It was May 2003. They garnished my taxes. Excuse the way I sound. I've had my tonsils and adenoids out. If you can't understand what I'm saying, so I'm sorry.
I can't.
But Your Honor, it was May 2003. They garnished my taxes. What they're seeking is interest, in which they gained more money than it was the original debt. And if they sent me paperwork in the mail this week, which on I'm sorry, the third to last page, it's checked off to where this judgment or order resolves the last pending claim and closes the case. And so now they're trying to garnish me for $884, which from my job, which from my understanding, I can't have any garnishments where I work, or I will be dismissed from the job itself. The $884 is an interest I feel is greed, which comes from a $78 ending, of which they did not get from my taxes, which I feel I shouldn't even have to pay the $78 for the simple fact on the third page where it says check twice that it closes the case from them taking my taxes.
All right, you gave me a lot of information there.
I'm so sorry.
That's okay. So slow down for me for just a little bit. Are you talking about the so you're looking at the debtor balance, the $78.75?
Okay, that's where they put interest.
And so you're talking about the 806 in interest? Okay.
It's 884 in
Yeah,
interest.
806. It's 806 in interest.
They're seeking
884 is the
884.
total, which includes the $78.
Yes, which I feel I shouldn't even have to pay the $78 for the simple fact, on the papers that they sent me in the mail, I read very well. And on the third to last, I have a paper of everything, all the paperwork that they've had over the years. And the third to last paper that they sent me on the judgment, it's checked off. They have checked off that this judgment or order resolves the last pending claim and closes the case entirely. So they're seeking money after they have checked this box off, stating that it closed my case.
So I think you're talking about the judgment, right?
It says there are no further issues to be litigated.
Right.
And then they come back.
That's litigation. That's different, though. That's different than whether there are matters to be collected.
Oh, okay. I didn't understand that. I'm sorry.
That's okay. But I agree with you. I don't understand why we've waited all this time to collect on
to come back. And then
1 second, Ms. Franklin, to collect on $28. I don't understand that part, Mr. Cox.
Well, Judge, what we do show in the ledger was that we've been collecting most of what's been collected over the past 2.5 years or 3 years. Going back to 2021, we got a wage garnishment of $73.80. In October of 21, we had continued withholdings. We were then through March of 2022. And then in March of 2023, we hit $1,639 in a tax garnishment. So I guess, yeah, we did bring it down in a principal level to that $78, but the total judgment amount has been being pursued. I don't know if that's what Your Honor was asking, but I'm just looking at the ledger relative to.
It all exceeds the first amount. First of all, it all exceeds. You've gotten more than what was even charged at the beginning. Way more. Over $1,200 more, if not more, of what the judgment first exceeded. So it's total greed at this point. And to come for my job for $78, it's absurd. And to put all that interest of $884, it's totally absurd. I would lose my job due to this garnishment, which I cannot afford. I've worked hard to get my life back on track. From my license as I came before you months ago, Judge, to getting my license, to getting everything on track. For this to come along. I can't afford to lose my job.
I hear you, Ms. Franklin. The initial judgment in this case goes back to May 27th of 2003.
Yes, ma'am. Yes, Judge.
And it was $1,651.52.
and they've gotten 2,000 and some odd dollars
So they've collected $2,030.
and seeking more.
I see. Mr. Cox, are you willing to try to resolve this matter with her in a breakout room?
Absolutely. I'm trying to look in terms of the garnishment she's objected to. I just want to confirm okay, it is a wage garnishment. Okay. I don't see that we've received any monies pursuant to the wage garnishment to
Because
date.
I've objected to it before you can garnish them.
Okay. So that's likely the case where the monies might be being withheld by the employer pending the outcome of this hearing. But I'm absolutely willing to speak to Ms. Franklin in the breakout room to see if there's something that
How
can be
much is
resolved.
being held?
I'm not aware of any, but
Do you know if any monies are being held, Ms. Franklin?
I objected to it before I went to my HR
Oh, do
And
you
I
object before they withheld anything?
before they can do this to me because I would lose my job.
All right.
HR already confirmed I will lose my job. So I had to hurry and come to the courts and file this objection.
I understand. All right. I'm gonna put the two of you in the breakout room. It appears you do owe them $78 still on their, they are entitled to, the law allows them to collect interest. I don't believe that the 889, I can say that right now, is appropriate at this point, but the other interest that has been collected is appropriate, and you do still owe on the original balance. So you need to see if you can work something out. Otherwise, I'll come back and make a ruling on the objection. Okay,
Thank you, Your Honor.
thank you. AAA Insurance Company versus Nicole Franklin, 03C1736.
again, Your Honor, Keith Cox for the plaintiff.
All right, Ms. Franklin, please unmute, state your name.
Nicole Franklin.
Thank you. Do we have any success in the room?
Well, Judge, we talked about the possibility for making a lump sum settlement offer toward what we show as the remaining judgment balance. She's unable to make any real lump sum payment at this time. And then we discussed the possibility of installment payments. She did indicate a desire to make installment payments of $50 monthly. Unfortunately, I don't have any authority to stipulate to that, but I did tell her that if she wished to make an oral motion with Your Honor for installment payments, I would not object to that. And just advise the court that that would seem reasonable based on her circumstances and the amount in controversy or remaining judgment balance. But I can't stipulate to suspending the garnishment. My client hasn't given me that authority.
When you say remaining judgment balance, what amount are you talking about?
The remaining judgment balance is $884.76, of which the $78 or so remains the principal, and then the remainder of the costs, or excuse me, the interest that's accrued, as this judgment has been, sitting for many years without her making any type of payoff or payments. So.
Right, Ms. Franklin?
Actually, they received payment. I didn't make them. They took, well, yeah, I technically did through garnishment, tax garnishment, but I don't know.
Do you want to proceed with your motion today? What do you want to do?
I just want this to be over. Like I said, I'm trying to further things. I just want this to be over. I can make payments, monthly payments. Right now, I'm only part-time. With lifetime medical, all of that. I don't know. I'm just so confused at this $884 thing, but I have no choice. I don't have a choice, it seems like, in the matter at all.
You want to make a motion for installment payments today?
Yes, ma'am. Yes,
Sorry.
Judge. Sorry.
That's okay. How much per month?
I guess the minimum of $50 maybe a month.
Thank you. All right, the motion for installment payments for $50 per month is granted.
Thank you, Your Honor. So will this stop the garnishment, release the garnishment,
Yes,
or
it will.
suspend the garnishment?
It will stop the garnishment. Are you going to prepare an order to this effect, Mr. Cox, regarding the installment agreement or installment order that I've made over your
Right,
objection?
Judge. When's the first due date on the first $50?
When can you pay the first amount, Ms. Franklin?
30 days from today. 30 days from the motion.
That would be,
September 9th is a Monday.
Okay, that's fine.
it's just typically the order that I have that's kind of pre-printed would release any funds withheld to plaintiff's attorney. I know she's made a representation that no monies have been withheld, so there may not be any. That would be something I would likely put in the order if that's what this
I'm not gonna
court's
do
ordering.
that because she's gonna lose her job.
Yeah, that's,
Loses her job, then you can't.
I don't understand that she told me in the breakout room that the representation was major. That's the case. I don't think that's legal, but I also told her sometimes the reality of the way things are is not exactly the way they should be, I suppose.
I have paperwork stating that we are not allowed for garnishment, being part-time.
Okay, I like I said, I did not ever question what you told me as being factual. I was surprised to hear it, that's all. And questioning whether there's a legality to that, but I'm not her attorney and we can't delve into that necessarily. Very good. Then what we will say is that her motion or objection should judge, and the objections are denied, but order regarding installment payments, oral petition regarding installment payments is granted. She's allowed to pay $50 a month beginning September 9th, 2024. Any monies withheld should be returned to defendant. Now, Miss Washington, Miss Franklin, what you need to do is take a copy of this order to your employer. I believe the court will send one. Judge, am I able to email this to the court to make this go quicker?
You are.
Okay. Yeah, if I get it back quickly, I will email it to you as well, Ms. Franklin, but you do want to present it to your employer. I believe the court will likely forward a copy, but I think what you want to do is make sure you get your hands on it as quickly as you can, take it to your employer so they're aware of the fact that garnishment's been suspended.
Yes.
And that way, that there's no withholding will be ongoing. And then on the order, I think itself, I'll put down how to go about making payments. The default is to mail in a check or money order to our office. So it'll be on the order itself, which then you won't have to bother to follow up with me. And then if you have questions going forward, contact my office.
Okay. Thank you.
Thank you.
We'll submit that order forthwith, Judge. We'll get it to you this afternoon.
Thank you.
Thank you, Judge Washington.
You're welcome, Ms. Franklin.
You can tell that the judge really did not like that and did not like having to issue that ruling. She said before the breakout room that the interest was exorbitant, but she cannot give legal advice. She can't direct that lady to challenge it. And Judge Washington knows the situation that she's in. If it's written in the policy that they can be let go for having a garnishment or for having, sometimes they put it in as a clause of morality or something like that. It doesn't seem like it could be legal, but especially if it's a work at will state, then there's nothing you can do about it. They can write whatever they want in the policy within, certain realms, but for the most part, they get away with a lot. But yeah, she's in a bit of a bind. She either pays what the lawyer wants for his client, or she fights it and has a judgment that they can garnish. But I think, I'm pretty sure if she had fought it and not accepted it, Judge Washington would have done something a lot more reasonable with that interest, because they failed to bring the case before the court for years. And that must have been a really high interest rate.
Credit Acceptance Corp. versus Donald Gordon, case number 19C 1054.
Good afternoon, Your Honor. Attorney Ashley Notice Hartman on behalf of plaintiff.
Good afternoon. Is Donald Gordon present? If so, please unmute your device and state your name.
Yes, Your Honor. Hello, my name is Donald Gordon.
Good afternoon, Mr. Gordon. All
Good
right.
afternoon.
We're here on a motion to set aside the default in this particular case.
Actually, Your Honor, I'm gonna let you know that I'm not trying to set aside the emotion. I know I do owe this money. Only issue I had with this in the first place is the mail that they sent to an address that I haven't lived in since 2017. So I'm not disputing at all.
Okay, so Judge, based on that, and I apologize because our computer systems are down, so I don't have our response in front of us or his motion. But based on that, he's admitting to the debt and admitting owing, which is one of the prongs of the court rules, is that he doesn't have a meritorious defense. Therefore, his motion should be denied under the court rules. And I would also ask for fees and sanctions MCL 62591, as this motion would be frivolous. He knows he owes, he knows he has no objection to that. So I'm not sure why he didn't contact our office for a payment plan rather than make us come to court today.
I think his complaint is that he didn't get proper service, ma'am. And I'm not gonna issue sanctions against an inappropriate defendant.
Thank you, Your Honor.
And Judge, I apologize. May I just state one more thing for the record?
You may.
Thank you. Also, this is a 2019 case. I assume the judgment was also entered in 2019 or even 2020. His motion would ultimately be untimely under the court rules as well. So he's got an untimely motion, no meritorious defense. So even if service was an issue at this point, it's just not an arguable argument that he can make. And considering he owes, again, I would just suggest he contacts our office and we can work out some type of resolution.
Why can't he talk to you about that today?
Oh, he can. I just don't have I can't pull up his file because our system's down. So I don't know what his current balance is. I don't know if there's a garnishment. I really, unfortunately, rely on technology too much. And since our system's down, I have nothing. So it'd probably be best if he gave us a call tomorrow.
Your Honor, they started garnishing my check before I even knew I was garnished. And like I said, I didn't get any mail to come to court or anything because I haven't lived at the address since 2017. So if they sent on there is 2019, I wasn't there. I didn't get no indication of anything. They just garnished my check. If I had got the mail that I was supposed to get to the addresses that I do have on my license, which are different, then I would have been in the court that day to even work this out. I would have never missed.
Well, I think the problem that we seem to have with this file is that when it was initially issued, apparently your firm didn't do a postal check.
That would be really strange if we didn't, because we do that automatically at the time of filing suit. So I'm not sure, again, I don't have my system, so I can't tell how he was served. Was he served by alternative service or personal service? I assume alternate if he's claiming he wasn't served.
Well, there was a statement.
I wasn't served. I don't live at the address. So
Please stop talking. There is a motion for the alternate service in here that says that postal verification was sent to the post office, but there is no documentation that that actually happened. And it looks like it was done at alternate service to the same address that he's saying he didn't reside at through tacking, which he wouldn't be there, and first class mail. I don't see any certified receipt. And wait 1 second. I see where it says it was sent to that address by first class receipt, but I don't see a return of that. And I'll let you know, counselor, if there's tacking. I see just tacking at an address that we don't have postal verification on. So I understand your argument that it's been past the time frame. However, the reality is if it wasn't properly served, then that's a problem for me. So I'm going to adjourn this, and the two of you should talk. And I'm going to adjourn this, like I said, and the two of you should talk in the interim time period and see if we can work out anything.
Great, thank you, Your Honor. And in the meantime, too, I'll also look for those service issues that we have, just so the court would have those for the record. I'm sure we have those on file. Okay. And then, Mr. Gordon, if you just want to contact our office tomorrow, we can discuss resolving it, okay?
Okay.
See you.
All right. Sounds good.
Motion for the
Thank you.
can I finish talking, please? The motion for the,
Your Honor, I got one.
oh,
I got one question for you, Your Honor.
sir, please quit talking over me. The motion for the
Yes, ma'am.
default in this particular case is going to be adjourned to September 26, 2024 at 2:15 p.m. Everyone should have a chance to work through the service issue and
Okay.
see if they can get a resolution between now and then. What is your question, sir?
Okay, on the garnishment thing, I'm still getting garnished, so it's,
So first of all, your issue with garnishment is not before me today.
okay. Yes, ma'am.
You have to
Got
file a separate motion regarding that, sir. Okay?
Okay.
All right, thank
All
you.
I don't know if it's her voice or if it's the fact that she just sounds so snotty, so entitled, so arrogant. There's so many words that she sounds.
Thanks, Judge.
Thank
Have a good
you.
day.
You're
Talk to you
welcome.
soon, Mr. Gordon.
You too. Thank you.
Thanks.
Willowwood Development LLC versus Letitia Montgomery, 240423.
Good
I'm
afternoon.
here.
For the record, Tom Hocking on behalf of plaintiff.
Good afternoon, Mr. Hocking.
Letitia Montgomery here.
Good afternoon, Ms. Montgomery. All right, we're here today on a motion for summary disposition. I believe this is an adjourned motion. I thought the parties were talking from the last time we were here. Is that correct?
Well,
No.
yes, sure. I'm wondering if we might be able to just go to a breakout room real briefly and see if we can work it out one last time.
I'll send you in your breakout room. The court will recall the case of Willowwood Development LLC versus versus Letitia Montgomery, case number 24C0423.
Hi, Letitia Montgomery.
Good afternoon again, Your Honor. Tom Hocking.
Good afternoon. The parties had an opportunity to talk today. Where are we with this, please?
Well, Your Honor, I thought we were getting close and I have a number that I thought we had agreed upon, but I don't think we do have a settlement. And if we don't, then I have to proceed on our motion.
All right. And Ms. Montgomery, I told you that they have a motion for summary disposition today, that if you do not reach an agreement and they win their motion for summary disposition, they get a judgment against you and they can garnish your wages. Do you understand that, ma'am?
Well, how can I read the motion and I tried to speak with Mr. Thomas several times about this case, and I haven't spoke with anyone. I spoke to one young man and it's wrong charges on this account. And he said that Mr. Hawkins was going to give me a call back. I never spoke to nobody about this account. So I just disagree with this. I don't know if I don't know how it worked. I don't have a lawyer. I even tried to, I'm on SSI and I've been trying to do the legal aid, trying to have them call me back and discuss this matter because I disagree with this. They not talking to me and they just want to throw all these charges on me, which I disagree. They don't even have the accurate amount on the paper that they sent.
Thank you. Mr. Hawkins, this is over a lease, right? And you're
Yes.
talking security deposits and damages. Is that what this is about?
Yes, it is, Your Honor.
So that would require actual proofs, right?
Well, it's our position that the defendant acknowledged that by making a payment once she knew what the balance was. But if the court wants proofs on it, I understand that. And I understand she's pro per. And I think we pretty much agreed with what she indicated what she thought was a fair settlement. And if she doesn't want it, then I guess we either hear our motion, or if the court wants to have evidence, then I'll be happy to follow whatever direction the court wants to go on it.
I understand. So there was a security deposit in this case of $705 initially, and then there were some balances that were due. She is disputing, it looks like, what are you disputing, ma'am, about this amount?
I'm disputing the November and December rent that they saying that I owe, and then the damages. I know it was some damages, as far as like the carpet maybe was messed up or whatever, but all the other damages, that's why when I did pay $75. I was trying to get my credit together. I tried to reach out to them when they sent me the letter saying what I owed.
Ma'am, I want you to just tell me what you're disputing, please.
I'm disputing the November and December rent, the kitchen counter damage, tile missing, worn stain, kitchen cabinet missing parts and damages.
So, first of all, Mr. Hocking, as far as the rents are concerned from November to December, what is your client's basis for still charging that? When did she move out?
Well, she didn't move out until November 14th. And technically, she's supposed to give a 30-day notice. So that's why they charged her from November 14th to December 14th. But in our discussions, I've indicated that I'm willing to waive that. I'm willing to waive the November and December rent, which she is complaining about. So I don't know if we can call that a moot issue or not, but we did agree that we would waive those fees. And I agreed that we would waive any interest or fees after we had reached that ledger that is labeled as list of damages for tenant that's attached to our motion and our complaint. So out of that, we would agree to waive the December and November rent. And that is what I came up with. It was a figure of $1,046 that would be waived in regard to that issue.
So you would leave a balance?
Yeah, the way I figured it out, and I thought when we had gotten to these figures was something that was going to be agreed upon, but I don't mind the court hearing what we figured. The figure on the total balance of basically was $25.96, and that was, the rest of it was interest and costs and so forth. But if we went back to that balance of $25.96, she's indicated that she wanted, the only thing that was in discussion prior to today was the fact of the November and December rent. So I've agreed to waive that. That would be bring the balance down to I had $1,717. So basically knocking $1,000 off that $2,500 figure. So, you know, they'd go down to about 1,700 is what I've gotten them down to. But then we came down to that figure and it kind of, you know, went back to the original thing because nothing could be agreed upon. I thought we had that agreed upon, that once those figures were waived, that was the settlement. But when we got down to the bottom line, I don't think we have an agreement.
So what I'm confused about is she has 705. I don't think these numbers are right. I just don't understand. So she had $705.
Yep.
That she had on hand already.
Yes.
And then you're saying that there is $1,371 for the washer and dryer, the rent that she didn't pay from October to November, late charges, and then court costs. So that's $1,371.
Yep.
And then I think the problem is the way this is written. So what total for the new charges?
The total of the new charges are, well, it'll be the 1,371 plus these other charges minus the 700.
Can you add this number here from this? All those, yes. Not together, not separate. I need that separate from the first time. I just need those new charges only. All right, so how much were you trying to say you're willing to settle this for? What's the total number you're trying to settle with her for?
1717. And that includes giving her credit for the security deposit and waiving the November and December rent.
See. All right, ma'am. I can tell you that I've looked at these numbers and it's probably in your best interest to enter into some type of a resolution, but I can't give you legal advice. You can have a hearing, you can do whatever you want to do, but when you add all those numbers together, that's probably the best you're going to do.
Well, I wanted to go
No, I'm
over.
not debating with you. This is not. a
No,
debate.
I'm just, can I
Ma'am.
just say something? Because
No.
they got something
No,
wrong
no.
over here.
Yeah, they got a lot wrong, and I'm telling you, it's in your favor. So you can keep doing what you want to do, but it's going to be against your best interest to do so.
So
What
what
do
is the,
What do you want to do? You want me to hear this motion and you want to move forward on this, or what do you want to do?
and I'm having to pay 1,700? Is that what the motion is for?
No, the motion is for you to pay what they have on this sheet.
I don't know what's on the sheet.
Okay. Well, do you have the sheet? They gave it to you. You just told me you read it.
Yeah, I did read the sheet, but he said different numbers. If he was taking all of that off, what is the new
There is
amount?
no off. If you're not going to agree to it, there is no off, ma'am. There is only on. Everything on this sheet.
I don't know. Could you explain it to me better what you're saying? Because I'm not understanding we just sat here and talked about that he's gonna waive some stuff or whatever.
Unless you reach an agreement. If there's no agreement, they want everything that's on the sheet. They're requesting that you pay that. There's no easier way to say that. You either agree or they're asking for everything that is here.
So you're saying agree to the amount that he
I'm not
already
telling you
said?
what to do. I'm telling you what you asked me to explain what position you're in, and I just did that. You can accept the agreement or you can actually move forward, and they're asking for everything on the sheet.
I can accept the agreement.
All right. So the agreement is for $1,717. Is that correct? Mr.
Yeah,
Hodge?
sure. I would ask that our court costs, I don't need an attorney fee, but I would ask the filing fee of $75 and the $30 service fee.
Mr. Hawking, I asked you very clearly, what is the number? Now you're changing.
Okay, no, that's fine. 1717 is fine.
All right. Have you guys talked about how this is going to be paid?
I'd be happy to listen to what she wants to do, Your Honor, as far as that, but no, we didn't discuss. We have in the past discussed potential payments, but today we didn't finalize any payments. So if she thinks she can make an offer, I'm sure that's probably okay.
All right. Why don't I put you two in the breakout room? You can come back and tell me what the exact agreement is so that we can put it on the record, and then you will be able to get it put into writing. Okay.
Okay. Thank you, Your Honor.
Thank you. We're back on the record in case of Willowwood Development LLC versus Letitia Montgomery. Have the two of you haven't, you don't need to state your appearances again. You had an opportunity to talk in the breakout room?
We
Yes.
talked, but we couldn't come up with an amount. I'd be happy to tell the court where we are, and maybe the court can just make that call because we're not that far out, really.
Okay.
Can I address that? Okay. This young lady is on SSI. She's not working right now. And she is offered $25 a month. I'm not able to accept that because realistically, that just would take too long. I did indicate that while she's on SSI, if she could pay $50 a month, that I would tell my client that's just the way it is, and that's what we would agree to. That's where it is. I can't really go back to my client and tell him $25 a month. But
All right.
that's where we are, Your Honor.
All right. Ms. Montgomery, is there something you'd like to say?
Yeah, I was just letting them know with everything going on with my monthly fee, I can commit to paying the $25. He even went down to 50, but with everything that I have to pay for and my children, is just, I don't want to commit to something and then I don't pay it.
Well, $25 is a very small amount. I will, at this point, say that you can pay $40 per month. I'm gonna come to her in the middle. So, okay,
Okay, thank you.
you're welcome.
I think that's a fair settlement to everyone, Your Honor.
All right, so the agreement is for 1717 at $40 per month, correct?
Correct. And I guess we should put a start date in there, maybe a month from now, something like that, or whatever day of the month in September would be good.
On what day of the month can you pay?
September the 4th?
On the 4th of each month?
Yes.
All right. And you're gonna prepare the document to this effect, Mr. Hocking?
Yes. Do you mind if I just send it in through the 7-day rule, or how do you want me to present it?
7 days, good. Just make
Okay.
sure, do you have her email address?
Yes, I do, because we've just, even while we were on breakout room, we were exchanging some documents by email. So I do have it.
Who do I send it to? Like, where do I send it? You're gonna
I'll
put
give
that
you,
in?
yeah,
Okay.
I'll put that information right in the order, but you can mail a check right to my office, made out to the plaintiff's name, or I can give you a number that you can do it over the phone and set up an automatic payment.
Yeah, they can do that. I can do that.
What format are you submitting this document in, Mr. Hocking?
Well, I was just gonna present it as an order of the court. Because if you want me to do it as a stipulated order, I guess I could do that.
No, you can do an order of the court, but is this a conditional order of dismissal? Is this a judgment? How are you doing this?
Oh, I'd like to just do it as a consent judgment, Your Honor.
All right, if you do that, my request is if she pays according to schedule, that it'll be set aside.
Oh, certainly, Your Honor. In
Okay.
fact, I don't know, if the court wants me to do a conditional dismissal, I can do it that way also, that judgment would enter if she doesn't make her payments.
For that, okay?
Yeah, that's fine with me.
All right, thank you. COD is forthcoming. What that means, ma'am, is the case is dismissed. So you won't have a judgment on your record and it won't affect your ability, won't affect your credit. And then what will happen is you pay according to schedule, it will never get on your record. If you don't pay, then you'll have a judgment on your record, which sticks with you for at least 7 years, not more. Okay?
Okay. Thank you.
Working hard today. Have a good day, everybody.
Thank you. I appreciate all your help on it, Judge. Thank you very much.
I don't know if she understands how much the judge really helped her, especially with that last part, making it so that it got ordered as a consent judgment. If she does her part and makes all of her payments, it won't affect her credit or anything. If she doesn't, though, then she screwed herself. She is a really great judge. She is. Hi. I gotta go back out and see if I can find Billy again. Ugh, that little turd. I've seen her frustrated, but I've never seen her lose her cool. She has that like artfully mastered and you're right, in a scary calm way. Yep, cat crossing. That was Earl. He's checking out the window. He's probably looking for Billy. Oh, thank you. That's a huge compliment. None. I'm sure that it's happened. I just don't have any proof of it. All right, let me see here. We'll go to another one of my favorites.
All right, court is calling 2024 CR 5454 and 2024 CR 5455. State versus Avery Anderson. Can I have parties announced for the record for the state? Defense?
Marissa Judovenko for Mr. Anderson.
And are you Mr. Anderson?
Yes, ma'am.
Are there any applications in this case?
No, Judge.
Counsel, have you received all of the discovery?
Yes, Judge.
Did you review it with your client?
I have reviewed it with my client.
In each cause number, the court will find that the state is in compliance with discovery. In each cause number, did you review the document entitled True Bill of Indictment with your attorney?
Yes, ma'am.
Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
I do, Judge.
State, in the cause number ending in 5454, are you proceeding on the indictment as presented? Any objection?
No, Judge.
And in the cause number ending in 5455, are you proceeding on the indictment as presented?
Yes.
All right, Mr. Anderson, did you review the documents entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions with your attorney?
Yes, ma'am.
Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand? And the cause number ending in 5454, you're charged with the offense of robbery. That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine. Did you understand?
Yes, ma'am.
And the cause number ended in 5455, you're charged with endangering of a child. If the state is able to prove up the enhancement allegations, the range of punishment will be anywhere from 2 to 10 years in prison and up to $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea with the state in either of these cases, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
And each of the cause numbers, you have a right to a jury trial, the right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. Did you understand? Did you understand by entering pleas in these cause numbers, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into plea bargain agreements in each of these cause numbers? Counsel, in each of the cause numbers, has your client been able to provide you with any defenses?
He has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Judge, I do.
Mr. Anderson, in each of these cases, has anyone threatened you, forced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes.
In each of the cause numbers, the court will find that defendant has knowingly and voluntarily waived his right to jury trial. In the cause number ending in 5455, according to the plea bargain agreement, state is proceeding on counts 1 and 2. And you'd agree that you've been convicted of a felony for purposes of enhancement. And in both cause numbers, the punishment is to be assessed at 10 years in the prison. There are no applications. The cause numbers will run concurrently and also concurrently with 727817. State will take in consideration 727818 and 2024 CR 5456. Did you understand that to be the plea in each of these cause numbers?
Yes, ma'am.
Defense, is that the plea in each of the cause numbers?
It is, Judge.
State, is that the plea in each of the cause numbers?
It is, Your Honor.
Did you review the paragraph entitled waiver of appeal paragraph with your attorney?
Yes, ma'am.
Did you understand it?
Yes, ma'am.
And did you sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions?
No, Judge.
Then in the cause number ending in 5454, how do you plead? Guilty, not guilty, or no contest?
Contest.
And in the cause number ending in 5455, how do you plead? Guilty, not guilty, or no contest?
No contest.
And to the enhancement allegations, how do you plead? True or not true?
True.
State any evidence to support the defendant's plea.
I have gone over that with my client judge on both cases and we have no objections.
All right, state you may be excused. And each of the cause numbers, did you review the document entitled Waiver and Consent to Stipulation of Testimony and Stipulations?
Yes, ma'am.
Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial? A right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
The court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, if we can go off the record for a moment, please. All right. After reviewing states exhibits 1 and attachments in each cause number, the court will find there is sufficient evidence to find you guilty. The court will find you guilty. And cause 5455, the court will find the enhancement true based upon your plea or true in states exhibits 1 and attachments. Are you proceeding with sentencing?
We are, Judge.
Anything you wish to say on behalf of your client?
Judge, we just ask that you follow the plea agreement.
All right. Why are you doing this, Mr. Anderson?
The
No, why you committed the offense? What's going on with you?
only reason I took it, I mistaken the lady.
I'm sorry, what?
I mistaken the lady for the wrong phone. It was just a misunderstanding at the time.
No, I mean, what does he mean? He's mistaken the lady for the wrong phone?
Judge, it's my understanding he had believed that that lady had taken his phone. He didn't have it. All of a sudden, he had it a minute ago and it was missing. He couldn't find his phone. He thought that she had his phone and he went to grab the phone to find out if it was his phone.
So he pulled a Karen on her? A full-blown Karen? That's your argument?
Well, did he return it to her when he found out it wasn't his? So, okay, your story doesn't make sense to me.
Happened so fast. Like when I took the phone, it led to me leaving and me returning the phone to her. She ended up making the whole.
So why would you think that she had your phone? Why not somebody else on the street have your phone?
I spoke to her. She kept walking and I was trying to tell her, like, if you have my phone, give me back my phone. I got arrested. And it became a misunderstanding.
All right, none of this makes sense. The court, does your client have any mental health issues or no?
I'm not to my knowledge, Judge.
All right, then you're just out here committing offenses. Do you want to spend the rest of your life in prison? How old are you?
31.
All right, you're 31. You've already obviously been in prison before. That's why there's an enhancement. And now you're going back to prison. If you have a mental health issue, you need to take care of that. If you don't, if you want something, you need to work for it. Otherwise, the majority of your life is going to be in prison. And by the time you get out of prison, you're going to be in the twilight of your life. Because once you pass 29, the years just come by quick, fast, in a hurry. And pretty soon, unless you're planning on living past 100, which maybe you will sometimes, maybe people will live to be over 200. Biblically, that's what they say. People live to be 200. Maybe you'll be one of those people who will do that, but probably not. And I say that because I'm in the twilight of my life. So once you get to be 50, it's all downhill. And you need to decide whether you want your downhill of your life to be in a prison, waking up to a bail that somebody else sets for you, getting up at 6 a.m. in the morning, constantly looking over your shoulder to see what other inmates are doing. Do you understand? All right. So in 2024 CR 5454, the court will follow your agreement. Court is going to sentence you to 10 years in the prison. Give you credit for any time served. This is run concurrent with 2024 CR 5455, County Court Cause number 727-817. Take in consideration County Court Cause number 727-818 and 2024 CR 5456. Anything else with regards to sentencing in that cause number?
No, Judge.
In cause number 5455, court is going to sentence you to 10 years in the prison. And so the record is clear. I'm finding you guilty of count 1 and count 2, and the enhancement true. 10 years in the prison. This will run concurrent with 2024 CR 5454, County Court Cause number 727817. Take in consideration County Court Cause number 727818, 2024 CR 5456, and legally, count 1 and count 2 will run concurrently. Is there anything else in that cause number with regards to sentencing?
No, Judge.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because it's a plea bargaining agreement in each of these cause numbers, and because you waive your right to appeal, and because I followed your plea bargain agreement, you do not have the court's permission to appeal. Do you understand? Because these are felony convictions, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand? All right, we can go off the record. From here on out, if you pick up another felony, depending on the type of felony it is, your minimum sentence is 25 years in the prison. Do you understand? And as I tell everybody, there may not be funding for education. There may not be funding for anything else. But guess what? People will always find funding to build another prison so that people can be housed at the prison. People will find more funding to build another jail if the jail gets overcrowded. But at the end of the day, if the jail gets overcrowded, guess what? They still gonna find a place for you. My understanding is the jail is overcrowded right now. Guess what? It's not stopping people from being sent to the Bexar County Jail. You had better start making a decision on what you want to do with your life. If you want to spend the rest of your life in prison, all you have to do is let Texas officials know that, and I'm sure they will accommodate you. All right, good luck to you.
Bexar County, Texas does not play around. That was a plea bargain deal. Yeah. So whether it be because he could not control his own temper and his own actions, and he assumed this lady has his phone, or he was legitimately trying to steal it from her, whichever the case is, they see it as a robbery. And because he already had a felony conviction, it's subject to an enhancement. And it's a 10-year sentence. The next time is 25 years. They don't play around in Texas.
All right, who's here on Albert Bishop?
There you go.
Are y'all ready to proceed?
We are ready.
Court is calling 2024 CR 1174, State of Texas versus Albert A. Bishop. Can I have parties announced for the record, please, for the state?
Jason Garrett.
Defense?
David Quayle for Mr. Bishop.
All right, and are you Mr. Bishop?
Yes, ma'am.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Albert A. Bishop who was placed on deferred adjudication in 2024 CR 1174 for the offense of stalking on March 28, 2024 for a period of 7 years? Is that you?
Yes, ma'am.
All right, state.
Yes, Your Honor. Violating condition for Bexar County, Texas, Defendant Albert A. Bishop. The detonator failed to report to the supervision officer as directed for the months of April and May 2024 in violation of condition number 4.
How do you plead to that? True or not true?
True.
Waiver remaining violated conditions.
Any objections to the state's waiver?
No objection, Your Honor.
Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in the prison and up to $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 4?
So,
Well, I mean, it's
yes,
not, I believe so.
yes, ma'am.
All right. So here's the thing. You may think you have an agreement with the state, but this motion to revoke is a contract with the court. So whatever you've agreed to with the state, I don't have to follow that. Do you understand?
Yes, ma'am. I told myself to
Now?
make the court.
Listen to me. Do you understand?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 4?
What else choice do I have?
These are choices you need to make. So, knowing that, do you still wish to plead true to violation of condition number 4?
What-
If you would like, we could have a contested hearing. And what would end up happening is the state presumably would call witnesses. They would probably call the probation officer to say that you did not report. And then I would make a decision on whether or not that probation officer is telling the truth or not. If I find that they're telling the truth, then I would find the violation true. Do you understand?
Yes, ma'am.
So, knowing all of that, do you still wish to plead true to violation of condition number 4?
Are you telling me you're trying to give me the whole 10 years?
What I'm telling you is
Yes, ma'am.
that you have a choice to make.
I just want to get this over with. I don't really.
Right, do you wish to plead true to violation
Yes,
of
ma'am.
condition number 4?
Yes, ma'am.
All right, court will find violation of condition number 4 true. Is there a proposed agreement?
There is, Your Honor.
There is.
Yes.
That agreement is to adjudicate guilt, revoke the individual office of use and position, and to dismiss him 3 years of sexual department.
All right, is that the proposed agreement?
It's the proposed agreement, Your Honor. It is.
All right, are you waiving your right to appeal?
Yes, ma'am.
All right. Can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
You can lower your hand, state your name for the record.
Albert Anthony Bishop.
All right, why are you not reporting?
I didn't get the date. I'm homeless. I don't have really no excuses. They didn't want to take the probation to begin with. I was going to take the time, really.
Okay, here's the thing. That ship has sailed.
Yes, ma'am.
Let's not talk about ships that have sailed because guess what? They're not at the port. You can't catch it.
Well, I'm not going to disrespect. I have no
All right,
excuse.
so
I
we
have
have
no
no-
excuses to give you, ma'am.
All right, so there are no excuses for your not
I'm
reporting.
not going to disrespect you by giving you no excuse.
I appreciate that. All right, the court is going to find violation of condition number 4 true. The court is going to find you guilty, revoke, sentence you to 3 years in the prison, give you credit for any time served. There's to be no contact with McDonald's. So McDonald's is going to be off your list of eateries. Do you understand?
Yes, ma'am.
And there's to be no contact with Trisha, Trisha Robles. Anything else with regards to sentencing from either side?
Nothing further from the defense, Your Honor.
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
All right, because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal.
Yes, ma'am.
Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, you need to make different decisions. Otherwise, guess what? As I told the last gentleman, Texas will find a prison that will accommodate you.
I heard you loud and clear.
All right, good luck to you.
Yes, ma'am.
I just love the way she says McDonald's. I don't know. That was the part that caught me on that one. I was like, wait, that's different. And then I had to go back and look at what else happened in it. Oh, yeah. Yeah, you see little things that can easily be missed. Yep. Oh. Yeah. Yep. All right, and then last but not least, we have Judge Satterfield tonight.
We are going to go on the record in State of Kansas versus Gage Williams Small. It is 2022 CR 0000491. The state appears by and through Ms. Norris. Mr. Small is at the courthouse. Thank you for appearing, Mr. Small. We had to convert these hearings today. Mr. Watts is appearing separately at his office. Back in April, there was orders made for intensive outpatient and some other things. And there must have been a new warrant that was issued after that in July, where it alleged, well, it looks like he did a 2-day dip off of that. What, Ms. Ashenfelter, why don't you tell me where we're at on this case?
Your Honor, we were back before you, April 2024, for some violations. He did a 2-day jail sanction from that. Since then, he's done a 2-day jail sanction for me. Now we just have the current warrant. And I believe that's all.
Okay.
The current warrant looks like it was that you signed it on June 4th. And he was arrested June 12th on it.
Okay. All right, I'm looking at it now. It looks like it's for not getting an employment, positive for fentanyl. I'm not sure if you did further testing, but perhaps trying to alter his UAs and discharge from Holland Pathways and no mental health evaluation. So he's not really made the progress that we thought he was going to make back on the 19th when this was all ordered. Mr. Watts?
Your Honor, I've had a chance to speak with Mr. Small. He would stipulate as to number one, that he has not obtained suitable employment, at least as of the date of this warrant show cause on the 3rd of June. He is now working at KFC. He would also acknowledge that he provided a positive oral sample test on number two. He would acknowledge that his urine samples were not consistent with human urine, was discharged with Holland Pathways outpatient for being non-compliant, and would acknowledge that he has not completed a mental health evaluation. He would waive hearing on that matter and stipulate to those violations.
Is that correct, Mr. Small?
Yes, Your Honor.
Okay. Well, I find that you further violated your probation and what we set out for you to do, certainly back on April the 19th, and we'll ask for recommendations from the state.
Your Honor, defendant has had basically 2 dips so far, one that the court gave him back in April, and then another that his probation officer gave him in early June. He was originally placed on probation in December for 18 months. So I don't believe that the court would need to do an extension, but I do believe based on the violations that a sanction is certainly appropriate based on his violations, and would ask the court to give him 60 days in the county jail, and then he report to community corrections and continue his probation. Believe that based on his positive drug test, that a drug alcohol evaluation and treatment would be appropriate, and ask the court to make that a condition of his probation going forward. And the court will need to address additional attorney's fees and the bids application fee as Mr. Watts is appointed.
Okay. Ms. Ashenfelter, how much time does he have left on his Senate bill treatment? I mean, this is a 2022 case. I don't think he was convicted until...
Your Honor, he wasn't sentenced until December of 2023.
Okay.
And I don't know that this is a Senate bill case.
It is not a Senate bill case, Your Honor.
What?
It's not a Senate bill case.
Oh, it was a border box.
Your Honor, he was an I, and it's a distribution or possession with intent to distribute.
It also looks like he didn't qualify because of his SASE score, I believe, if I'm looking at the right paperwork.
Okay, whatever. He should have been Senate bill. I mean, that's what Senate bill's all about. They've expanded. I don't know why it didn't include him. So he's having to pay for this treatment, or are you finding funds for him, or what's the deal? Because he's attempted a number of things.
Well, Your Honor, he has insurance, and then everything else has been state funded.
He has insurance such as CanCare or Medicaid or what?
I don't know the specifics. I believe it's through his parents.
All right, Mr. Watts.
Your Honor, frankly, I would join the state's recommendation. I think somewhere in the 30-day range rather than the 60-day range is sufficient. This young man has not had, over the course of this case, a significant stint in the county jail. He's served a couple of days here and there for dips, but he's not had a long-term stay. To be perfectly honest, I think a long-term stay might do him some good, although I think a 30-day stint would be sufficient rather than a 60-day stint.
Okay, well, I don't know what's going on with you, Mr. Small. Your case was very odd to begin with. It was somehow you manufactured a way to get ketamine delivered, which was a drug that was not even in popular use, at least in Butler County at the time. Now it's more readily being used, but meanwhile, you had 150 grams and you were a border box with no criminal history, which is also odd, but no criminal history. But you or your family paid a lot of money for a privately retained attorney that represented you, that argued that this was just a aberration, meaning that it was a one-time fluke thing with you. And then I put you on probation and it's been nothing but failures. And now you're testing positive for fentanyl. So I do not understand what is going on with you. You're what, maybe another year older, maybe 22, going on 23.
I'm 23, Your Honor.
Is there anything you want to say? Because I'm inclined to send you to prison. That's where I'm at with you. That's the impression I'm ready to make with you. Because I just think that you have no intention of getting drugs out of your life or out of your system.
I understand the frustration. I do. Since I got this job, like I've been doing better. You know, I still had to slip up, but I know I need to get back into treatment. I need to do the bit. Once whatever happens after this, like I've made it a personal goal to try and get sober and do the bit, not just for like my family around me, but for myself too. Yeah.
Well, I mean, I get honest with people. If you can't do it, if you don't want to do it, it's better to just be done with it and take care of your sentence now rather than later, because the way you're going to end up in prison anyway at some point. And I don't want that to happen to you, but I don't want to keep dragging you or us or anybody else through this if it's pointless, because you're not that invested in it or awakened by the fact that you're on probation subject to going to prison. Which KFC are you working at?
The one here in town in El Dorado, Kansas.
Okay. Well, I hope you can get work release because you could walk there or ride a bike to and from. It's not that far. It's not that close, but it's not that far for a young person either. So I hope you can keep your job because that's the one thing that you figured out how to do, I guess, in the last 4 months. Which I'm glad, but I don't think your KFC job is going to rescue you. It's going to take more than that to dawn on you that this is real and that it's serious. And the drugs you are using are life-threatening anyway. So you're playing with fire. So I just don't understand why you haven't realized that you got an opportunity to clear all this up and clean it up and get on the right track back when you entered the plea and had private counsel and got probation. But all right, I'm going to order you into custody for 60 days with work release.
Thank you, Your Honor.
I'm hoping you can figure out how to accomplish that, but I don't know. And then I'm going to reinstate. I thought Holland Pathways was a very good treatment program. It's touted as one of those better, nicer, private treatment programs. What was wrong with that program?
Nothing was wrong with the program. I have a bad habit of self-sabotaging and I don't know.
It wasn't enough fun for you, or I don't know. I hope you can figure it out. I hope that when you're not at work, you're in jail, looking up at the ceiling and contemplating what's driving you, what's motivating you, what's behind this, what's going to change. Okay? And I really do. I hope that you can get this figured out and get it turned around and get it behind you. Okay? So, I don't think that you have a lot of credit. I think you have like 3 days or something on your sentence. Now when you get done, you'll have 63 days. But you still have the rest of that sentence hanging over your head. All right?
All right.
All right. Anything further today?
Your Honor, attorney and bids fees.
I'm going to waive. I'm sure he's not making much more than $10 or $12 an hour. How much are you making at KFC?
$10 an hour.
Okay. All right. We are adjourned.
Yeah, thing is obviously only with this is your mom. Yeah.
We'll be ready for Cinderella whenever you are there at security.
Your Honor, I'll need to do a brief breakout with Ms. Heist, and it shouldn't take.
Okay, that's fine because I think we're going to bounce back to Mr. Andrews' case.
Thank you, Your Honor.
Figure out what I did with it here.
And that breakout room can be in court security 3, please, Amy.
All right, we're going to go on the record in state of Kansas versus Dylan Michael Philmeyer. It is 2022 CR 000445. The state appears by and through Ms. Norris. Mr. Phil Meyer is currently in custody appearing by Zoom. Separately from his attorney, Mr. Andrews, who is appearing by Zoom. This show cause involves allegations that you failed to report for an office visit, you were discharged from Meer due to non-attendance, and you didn't re-engage in any Senate bill treatment, and that you haven't made payments as of March. Announcement to the court.
Your Honor, Mr. Fellmeyer would stipulate to violations of the probation.
He had a violation hearing back in, was it January?
That sounds about right, Your Honor. I was thinking it was the beginning of this year. I don't remember the exact date.
It looks like it was January 26th.
Yeah, and he got a 2-day sanction. All right. Sir, are you going to stipulate that you violated your probation by not completing your treatment?
Yes, Your Honor. I have since I completed a treatment in here on my tablet. It's through Adobo, but it's a substance abuse class that I took online, and I completed it just a couple of days ago.
Okay.
But
okay, let me get recommendations. Okay, Ms. North, recommendations.
Your Honor, this is defendant's second warrant to show cause in this case. He was originally placed on probation May 15 of 2023 with community corrections. And Your Honor, he was in front of this court in January for a probation violation, which are similar to the ones that he has stipulated to today, not reporting and basically being unsuccessfully discharged from treatment. So basically he's having the same problems. And it doesn't appear that he's interested in reporting to Mr. Catley, nor is he interested in doing the treatment. He has SB 123, but I don't know, if he actually has any of that left, because I'm not sure exactly when he started the initial treatment, but either way, he's not likely to get the full benefit of the SB 123 and the treatment paid for if he's not going to attend. And this is just one of many cases that Mr. Fielmeyer has. He has probably 6 or 7 open cases in this jurisdiction, newer cases. Obviously, this is a show cause. And then I think he also has some stuff pending in Sedgwick County. Your Honor, the state would recommend, he has had a 2-day dip. The state would recommend that he be revoked and he be ordered to serve the balance of the underlying sentence. He doesn't appear to want to participate, and is just taking up Mr. Catley's time. And it appears that prison seems likely to be a better choice for him at this point. And Your Honor, the court will need to address court-appointed attorney's fees and the bid's application fee as Mr. Andrews is appointed.
So does he have pending cases that he has picked up while he's been on probation in this case? Since May 15th of 23, has he picked up new cases?
I believe so, yes, Your Honor. Let me...
I don't know. He's had cases that have been pending for quite some time. I don't believe that most of them, if not all of them, I know at least preceded the last probation revocation hearing. There may have been a new case that was filed since then, but I think it may have been for an incident that occurred prior to then, if that makes sense.
And Your Honor, he's got, let's see. Let's see, the charges for, in one of these cases were, it was December of 2022. So and actually several of his cases are from 2022. And then he has, a 24 case, 24 CR 174. It's a violation of a protective order. And so, yeah, the bulk of his cases are from 2022, and there's like 7 of them. And then, like I said, the 24 CR 174 is the most recent one. And basically all of those are still open and pending.
Well, we probably would have known that at the time that he entered the plea, right? That he had other pending cases. I mean, this is not news. This is not news.
I would assume so, Your Honor. But yeah, there's one though that has occurred since he was placed on probation.
Why would a violation of a protective order be a traffic case number?
It's not a traffic. He has lots of traffic cases, but he also has lots of criminal cases. They're like they said, there's like 8 besides this show cause that are still
trying to figure out what he's charged with in the 24 case.
It's violation of a protective order.
Okay, so is it 2024 CR 174?
Yes, CR 174.
Oh, TR. All right.
I thought I heard TR at first as well, Your Honor. So
okay.
Sorry about that. No, and that actually, Your Honor, happened on, that one was actually on April of 2023. So it didn't actually, it just was filed.
Yeah.
Okay.
So it was filed prior to being placed on probation in this case. Or the occurrence was alleged to have occurred before he was placed.
It was filed after he was on probation, but the incident was from before.
Okay. Mr. Andrews?
Your Honor, I understand where Ms. Norris is coming from. I would state that first, Mr. Fellmeyer successfully completed his inpatient treatment, graduated from that in February, and then I believe it was February, but he did complete his inpatient treatment. Then he was to do outpatient treatment, and that's what he was unsuccessfully discharged from. And he, as he indicated, he tried to do what he could while he was in custody. A lot of it was due to some transportation issues of getting there. Then essentially what happened in March is he was ordered to appear in person for a hearing, to come to the Sallyport for a hearing, and he went to his attorney's office instead. And the court essentially issued a warrant for his arrest for not appearing in person. And so as a result of having that outstanding warrant, he didn't appear, he didn't report for his probation. There's a pretty big change though between what was going on back in February and March and now, and that's that simply that Mr. Fellmeyer has a child on the way, and that is giving him a different motivation, if you will, to be successful. As I said, he did complete a little bit of treatment while he was in custody. He will do whatever he needs to do as far as the Senate, successfully completing a Senate Bill 123 treatment once he's released. He will has employment lined up that he will be able to make payments on his outstanding costs, and he will make sure to report as needed. And so for those reasons, we believe that a sanction is appropriate, but outright revocation and serving the sentence is not necessary in this case. Instead, what we would ask is that his probation be reinstated for a year and that he serve a 30-day sanction on this case, and then be placed back on probation to complete the terms of his probation.
Mr. Philmeyer, is there anything that you'd like to say?
Yeah, I just apologize that I wasn't making the 100% right, 100% right. Sorry, I didn't have the right mindset. Now I have a daughter on the way. She's supposed to be born in December, and it's just completely changed my whole thought process and thinking. And I'm just looking forward to being there for my kid and my girlfriend.
So is the mother of this child that you're having the same person who is the alleged victim in the
No, Your Honor.
of a protection order?
No, Your Honor. That previous person was Rand Hennessy, and it was, I believe, the phone contact or the texting on the tablet is what that violation of a no contact is going to be. I'm just assuming because it's nobody filed any paperwork. It's just whenever there's a case, there's a no contact order from the state, I believe, is the reason on that, Your Honor.
Well, it looks like to me back in July of 2023, you got kicked out of Meer.
Mm-hmm.
Then they got you back into treatment.
Yes, ma'am.
And it looks like did you complete Meer, but then you did not complete the outpatient portion?
Yes, ma'am.
And then why did you fail to report?
I had court with Judge Ricky, and he pulled my warrants or put warrants out for my arrest, and I just didn't report after that, Your Honor, which I should have.
So you have to go back in front of him?
I don't think so. I have Miss Webster and Mr. Crum, I believe, on my next court dockets here in late this August.
Did anybody else catch that, oh crap, look on the judge's face? You have to go back in front of him? Like, she knows if he were to have to go back in front of Judge Ricky, it'd be a bad day for that dude. I will say, kids absolutely can change a person's mindset. They can change a person's trajectory in life. I really hope, both for his sake and for the sake of his coming daughter, that he's being honest with himself about getting sober, about following through with these court cases, getting them over with, and turning his life around. I really genuinely hope that he has the strength to do that. And those little bundles of joy can be a wealth of strength, but they can also be a test of your character. They will push every button you have, and they'll find buttons you didn't know you had. I just hope he's strong enough.
So,
okay, because I knew I'd be tempted, but I wouldn't. As long as you were appearing, I wouldn't issue a warrant if you were sitting in your attorney's office.
Yeah.
I'd make you go to the jail, and then if you didn't, I'd put out a warrant for you. But so I didn't think that was me. I don't think that's something I've ever done. But at any rate, none of it's really that great of an excuse.
I know, Your Honor. I apologize.
Mr. Catley, how do you feel about Mr. Philmeyer? I guess I have. Here's the only reason I have mixed feelings is because these other cases really predated from the time I put him on probation. And so what I'm interested in is what he's done, hasn't done since 5/15 of 23. And I know that may be narrow, short-sighted, but that's what I'm focused in on. And then if he did complete I was thinking he was unsuccessfully discharged from treatment at Meer, but he actually was discharged from Meer successfully. It's just, well, you say due to non-attendance, so he wouldn't have been discharged. So did he complete inpatient treatment or not?
He did, and then he was referred for outpatient treatment, and he failed that.
Okay, so Mears offers inpatient and outpatient.
Correct.
Okay. And then he wasn't reporting to you. What was he like when he was reporting to you? Was he respectful? Was he like he is today, or was he totally different?
He's when you meet with him in person, he's pretty much like what he is today, Your Honor. However, I mean, if I recall right, on his appearance in front of Judge Rickey, I believe he was in a car, if I remember right. I don't believe he was at his attorney's office, if I recall. I may be mistaken, but he was supposed to be on his way.
Yeah. Where is this place that you think you might be able to get a job?
It's called Pruitt Flooring. It's over in Wichita. And Mr. Ketley had mentioned that he also does the reporting in Wichita as well every Tuesday, I believe, right, Mr. Ketley? Or is it every other Tuesday at the Wichita?
That's until I transfer it, yes.
Yeah. So he said I'll be able to report in Wichita, which would be a lot more helpful in reporting.
Well, I don't know. They don't put up with much there, honestly. It's kind of somewhat of a spider's web because you're not their jurisdiction and they're doing it as a courtesy and they don't tolerate very much. I don't know. I think, Ms. Norris, I'm not just trying to disagree with everything that you say today. I'm really not. I do respect your opinions and your position. I think I'm going to order an additional 30 days for a full 60, and then I'm going to reinstate your probation, see if you can't complete outpatient treatment.
Thank you, Your Honor.
Now, if you can't complete outpatient, you can't do your stuff, then I'm pretty positive I'll have you in jail by December, and you won't even be around for your child's birth.
Yes, Your Honor. Is there a possibility of work release? I can get a job here in town. I know somebody that works here locally at Hog Wild Barbecue.
Yeah, and he on probation or parole or something. The last guy I knew that was working there. Did you meet him in jail?
No, I know his girlfriend. She's a regional manager there, if you're referring to Mr. Williams.
Yeah.
Yeah.
I don't. That's a great place for you to work. Look, I'm sending you to prison. I think I'm just going to have you sit tight for these 30 days. Think about where you're headed, what you're doing, develop the very best plan you can, get your head in the right place. You're doing that because you did that certificate program.
Yeah, I've been reading a lot of parenting books. Sorry, I don't mean to interrupt, but I've been reading some parenting books too. So
okay, let's just focus on you, where you're at, where you're headed, where you're going, and what it is that you need to do to be successful, and just stay still and then be ready when you get out to hit the ground running.
Thank you.
And
all right,
Your Honor, I think you would need an extension and then additional attorney's fees and bids fee. And Your Honor, were you wanting him to basically serve a 60-day sanction? So whatever it, or you want him to just, whatever his credit is, you want him to do 30 days from today?
Well, he's done over 30. I can't give him more than 60. So it's got to add up to 60. So it's 60.
It would be, he has 38 days as of today, so it'd be 22 more to get 60.
Okay, that's what I'm ordering.
Okay.
Thanks. $100 bids added. Extension. See, I didn't give you an extension back in January because I told you I don't like extensions because you either get motivated and get it done so that you don't have the case hanging over your head, or you end up back in front of me the longer you're not progressing. In other words, my theory is you progress quick and get it done when you're motivated. And the longer it goes on, the more frequently you fall off the rails, basically. But I have to extend it or we have no ability to impose your sentence if you fail. And that's got to be a consequence. So, Mr. Ketley, how long, when do we extend it to?
I would think if you would just extend him an additional 6 months from his original termination date, he ought to be able to get everything done by then, I would think.
All right, that's what I'll order. Okay.
Your Honor,
Yeah.
he does have other cases with Judge Ricky that still has a no bond hold, so.
Okay, well, hopefully if he's lucky, he has Mr. Andrews on his other cases and he can try to get him in front of Judge Ricky before then. I can't do anything about any of that. I can only do what I feel's right on my case. Okay.
Your Honor, I think the only other thing is I don't remember if the court had issued a ruling regarding attorney fees and the bids application fee.
I must have been under my breath. $100 bids application.
Thank you, Your Honor.
Okay. Thank you.
Thank you very much, Your Honor.
I really have hope for him. He seemed very respectful here, and that goes a long way. He even apologized when he spoke over the judge when he was answering something. So I don't know. I think he has a chance. I'm hopeful. I really am. I am hopeful for him. As far as his original charge, I believe it was drug charges. I am not 100% certain on that. But they did say that he had a number of both criminal and traffic charges. So whatever he has, I hope it's all behind him. Yes. Yeah. He says he can do both CR and TR. No one's going to hold him back.
Mr. Andrews, thank you for appearing.
Thank you, Your Honor. I hope you get to feeling better.
Yeah, I hope I'm at I don't know. It seems to be getting worse every day.
It's not.
I test positive on Wednesday, but I test positive today.
Oh,
So
yeah.
Well,
hopefully by tomorrow you'll be feeling a lot better.
Yeah, hopefully I wake up in the morning. That's all. And I can breathe. All right. Thank you.
Thank you, Your Honor.
Bye.
Judge, I'm sorry. Did you assess any further attorney fees on Fielmeyer, or was it just bids?
Just bids.
Okay, thank you.
Okay. That's all I have here, Your Honor.
Thank you. Have a good weekend.
You try and do the same.
All right, Mr. Watts, you have Bramlet and Sullivan.
Bramlet is me, Your Honor. That's why I'm here.
Oh. Well, who do you have, Mr. Watts?
She's at court security right now.
Oh, okay. Oh.
But not Christie, Cinderella Heist. What did it say?
Sullivan is a motion for judgment on bond. Okay. All right. Let's go on the record in State of Kansas versus William Dale Bramlet, 2023 CR 000459. The state appears by and through Ms. Norris. Mr. Bramlet is.
Your Honor, I don't believe he appears. This is a motion for judgment on bond.
Oh, on Bramlet?
Correct.
And the bondsman is here, Your Honor.
Okay. I'm not sure. I don't think the defense attorneys ever need to appear for these.
I didn't think so. Yeah, okay. I didn't think so, but I got an email saying that he was on, so I got on.
Okay. All right. Well, thanks. Sorry about that.
That's okay. Have a good weekend, everybody.
You too. So This is John Roberts. What's your
Doug
name?
Markey.
Are you Mr. Duncan? Doug Markey?
Yes.
Okay. So Mr. Bramlet failed to appear back in
Yes.
February of this year. And he was on a $10,000 bond. And I issued a no bond hold if we could find him. And then, of course, they just, as a matter of course, do a motion for judgment, which I usually grant unless you have a lead on him.
Yes, ma'am. In March, I found him down in Texas, in jail in Tarrant County. And this was in March 26th. And then on March 27th, I brought in a sheet of paper and for the court to sign off on the bond because he was in custody. And
okay, hold on. Okay, that I've interpreted the statute to require that they be in the jurisdiction or at least in the state of Kansas. Otherwise, we have to extradite. So it doesn't relieve you of your obligation on the bond just automatically as an operation of law because they've been secured in another state. Miss Norris, did you get notice so that you could put a hold on him? Is this a case in which you could have extradited or you are extraditing Mr. Bramlet?
Your Honor, I'm just looking at some notes. It looks like that our sheriff's department is aware. Let's see. The sheriff's department is aware that he is in custody in Texas, and it's my understanding that they did put a hold on him in mid-June.
Okay.
Based on some emails that are in the file.
Mr. Markey,
yes,
do
ma'am.
you know if he's got new charges in Texas?
No, ma'am. I do not know.
Well, it sounds like we're going to have to extradite him. What I'm going to do is just set this over until probably December to see if they've contacted us to either he'll waive extradition, we'll go get him, and maybe I'll see what the cost is to go get him and decrease your judgment just by that amount and waive the rest. Or I'll waive it all. I'm not sure, but let's see if we get him back to our court in our jurisdiction. You know, had you had a bounty hunter that just brought him back to Kansas, we'd already have him here. And I'm not suggesting that you are in a position to be able to do that comfortably, but now we're going to have to go through the governors of the state of Texas and of the state of Kansas to get him back if he doesn't waive to come back. So,
okay, I'd be happy to go get him.
Well, why don't you contact Sheriff Huey and see what he thinks about that. He may deputize you and let you go do that. I don't know.
Oh.
I'm going to give you a new court date, though. I'm not going to grant judgment today. Okay, we're going to set this over and see where Mr. Bramlet ends up. Bramlet, who I don't know what he's been picked up on, that he's still in Texas custody, but if you find out anything sooner, let me know, someone. Otherwise, I'm going to check the status of this case on December 20th at 2:30. So, you know, you won't have a judgment against you this year, and you may not have one at all. Okay. I am trying to work with you. I will work with you.
That's awesome, Judge.
Okay.
And I'd like to work with the court. What jail is he in? Is he still in
Can you tell
Tarrant
that?
County?
Your Honor, I don't know if he's still in that facility or not. My guess would be yes. Based on the emails I got from the sheriff's office, but she doesn't specifically say. She just says, you know, that they got a hold on him, and we had basically provided the information. I think, well, actually, Amy had forwarded it to myself and Mr. Favre about basically what the bondsman had said about Tarrant County. So I would assume that's probably where he still is, but I don't know that for certain.
Okay. Again, that's probably a starting point, but check with the sheriff because they'll be able to easily track him down if he's still in custody.
Yes, ma'am.
And you know, if he was in custody and you notified us and we lost him, that's not necessarily your fault either. So, but just bear with us and let's see if we can't make some progress with him, or at least get a little better update. Like I said, if you've got information that you want to present to me before December the 20th, just let us know. I can move the date up.
Yes, ma'am.
Okay, thank you.
Thank you.
All right, Mr. Watts, I do have one more judgment on bond. If you don't mind. And that is Danielle Sullivan, 2020 CR 525. State appears by Miss Norris. She was just on $1,000 bond. Failed to appear, so a motion for judgment was filed, and I reset her bond. I didn't hold her without bond to $3,000, and that was back in January of this year, January 26th. Mr. Duncan, are you the bonding agent with Second Chance Bail Bonds?
Good afternoon, Your Honor. I am.
Okay. You have a lead on Miss Sullivan?
We do, and I'm here asking for just 30 days should be sufficient enough for us to bring her into custody at this point. We're pretty close, so.
Okay. All right. So I'm going to grant you a continuance 30 days. My interest is getting the people back in front of the court more so than taking your money.
Thank you.
How about September the 27th at 2:30?
That works.
Okay. Now, if you've got her in custody, especially in our jail, but if you've got her in custody in the state of Kansas by then, and you want to send me an order for discharge, we probably would cancel this hearing and I'd release you from the bond.
Okay.
If you got any new information, let me know. Maybe a $3,000 surety was not a good idea, but these are misdemeanors. I think was it was originally a felony drug case that turned into a misdemeanor, but at any rate, hopefully you can get her back in front of us so we can figure out what's going on. Thank you.
Perfect. Thank you. Get to feeling better.
Thank you.
Thank you. Bye-bye.
Okay. Now, Miss Heist. All right. I'm glad you found transportation because you have a couple cases and the last thing you want to do is not appear for them. Absolutely. The case that you have with me is 22 CR 430. Mr. Watts is here appearing as well as Miss Norris. I sentenced you back in January, ordering some restitution and asking that you complete Senate bill treatment. And a request for revocation was issued in July. alleging that you failed to report to your Sedgwick County ISO on February 7th, March 18th, March 27th, April 8th, April 29th, May 6th, and May 14th. And you had positive urine samples for marijuana in January, a higher, if you can count, if you can quantify those tests, higher count the next time. And by April, your count was apparently going down. These were all positive tests for marijuana, and you weren't attending treatment. Mr. Watts?
Your Honor, as to the warrant to show cause, I spoke with my client. She would acknowledge she failed to report to her ISO as directed on the dates as outlined in the warrant to show cause. She would also acknowledge she tested positive for the urine samples. I will tell the court, my client tells me that what she was actually using was not marijuana per se, but Delta 8, which can be bought legally, or at least can be bought over the counter. As I told my client, it's somewhat a gray area whether it is legal, but I've also informed my client that for purposes of probation, it's marijuana and you can't use it. Whatever the legalities might be for in other circumstances. And finally, she acknowledged that she failed to attend her substance abuse treatment. She tells me she is just out of an inpatient treatment at this point as of a few days ago. But as of the time this motion was filed, that she had not completed and failed to attend a substance abuse treatment. She would stipulate to those violations and waive hearing.
Yeah, and I don't know if you know this or not, but she got picked up on new charges for possession of methamphetamine and paraphernalia.
And those were not Delta 8.
I do, Your Honor. I have that case in front of me. It sounds like we're going to take it up as a first appearance.
Well, I don't know. It's Judge Hart's case.
Oh.
I don't know that.
Your Honor, she's had a first appearance.
Yeah.
That was on July 3rd, and it's actually set with this court on August 29th at 2:30.
Are we talking about 24 CR 309?
Yes.
Yeah, it's set today for, I don't know, Judge
It's set
Sanders.
today, but I'm not sure why.
It's my file shows August 29th.
Well, I think that was a typo because today's August 9th.
I believe Judge Sanders said it with you, Judge, because you had her other case.
Right.
With the same judge is what he did.
I understand why he did it, and I imagine Judge Hart's PHC's clear out to October, and he didn't want to not have this case doing something for that long.
It is on the first appearance list. It's October 15th.
Yeah. Well, all right. So, Ms. Norris, what is your recommendation? Sticking with my case, what's your recommendation?
Your Honor, they will be requesting that the defendant do a 2-day dip. And let's see, she was placed on probation in October for up to 18 months. So I don't think she needs an extension at this point, but I do believe a 2-day dip and then back on and complete all of her probation conditions. And that Your Honor will need to address additional attorney's fees and bids application fee.
Mr. Watts, anything you want to add?
Frankly, Judge, we join the state's recommendations of a 2-day dip at this point.
Okay. Anything that you want to say, Ms. Heist?
No, Your Honor.
Okay. Honestly, I'm going to order a 3-day sanction on you, the maximum I can do. And I hope that you get this figured out between your inpatient, your 3 days, and being reinstated, because this case, if you're convicted on it, could be a basis to revoke you and run consecutive time to put you in the women's correctional facility for 2 or 3 years. And so it's not just that the whatever it was, marijuana or whatever, Delta, whatever, it's the methamphetamine. Now's the concern. And if you can't do treatment and you can't stay sober, you go to prison. It's just that simple. And I'm trying to look here to see what your controlling term. You probably have around 14 months. So you've got a lot at stake now. Now you got bigger problems besides even just this revocation where you're entitled to a small jail sanction. Now you got a new case that you may go to trial on or end up getting sentenced on. And now you were on probation with a new charge. So the best thing you can do, get yourself in treatment and stay in a treatment program and stay sober and work your program. Okay?
I really did love, I'm sorry. I really did love Bel Air Recovery Center. I think it did a lot for me. I'm also attending their intensive outpatient. So
who's your ISO?
Michelle was my ISO through Sedgwick County. I currently also am keeping in contact with an ISO through Harvey County.
Okay. That's who you need to convince that you're doing well. Okay. And your actions speak louder than even your words. Okay. But I'm glad that you're starting to get some benefit from the services that you're getting. Jim, do you just want to, I'm going to let you decide. Do you want to keep this case with me or it's assigned to Judge Hart and just bump it over to his next PHC docket?
Frankly, Your Honor, I think it makes a lot of sense to keep cases with a single judge when possible.
Okay. Well, normally he doesn't mind if I take his cases for him. So, but I think I'm going to give you time to look at discovery and talk to her about it. We could set it directly for preliminary hearing, but it's probably better that we put it on a PHC docket, which would be September 23rd or October 21st. September 23rd at 2:30 or October 21st at 2:30.
Well, Your Honor, at this point, what I have is an affidavit and nothing else. So given that reality, I think I'd just soon set it to a docket. If I'd had the rest of it, I'd say just go ahead and set it for prelim, but I do not.
Okay. All right. On the record in 24 CR 309, the state appears fine through Ms. Norris. Ms. Heist thankfully appeared. And Mr. Watts is present. He's appointed on this case as well. And we've set it for PHC in front of me on October 21, 24 at 2:30. Okay?
Yes, ma'am.
All right. Thank you. They're going to take you into custody. They will release you after 72 hours. And $100 bids. That's what I want to do. Be added. Please. Thank you. All right. Is that it for today?
That's what I have, Your Honor, unless there's more fun we should have.
No, I don't think so.
Your Honor, I'm out of files.
All right, great. Thank you, everyone. We'll see you next week.
Thank you.
Good afternoon.
The judge is going to celebrate with a box of tissues. Oh, my heart breaks for her. I guess a bunch of people in the Kansas courts arena has contracted it. So I hope they all get better. I love them all. Seriously. Oh, golly, that would be too much fun. That would absolutely not be an idiot sandwich idea. I love him. Yes, absolutely, Cuddle Snugglesworth. That girl just, we were all talking about how snarky she was, snarky and arrogant and full of herself and just not able to read a room very well. You know, you'd think with the judge shooting her down as cold-toned as the judge did, that she would have gotten a hint. But no, she took no hints. She is a you must spell it out with crayons kind of person. Yeah. I'd get pulled over on purpose. If Gordon Ramsay were a judge, I'd get pulled over on purpose. So, yeah. But that's what I had for tonight. That's the fun that I came up with. I hope you guys all had a really great time. We have one more piece of business to do. We got to see who won the caption contest. Oh, wait a minute. Oh, sorry. I'm like 10 hours and 15 minutes early. The caption contest will end at midnight my time, Central Standard Time. Tonight, Saturday, because it's, now Saturday here. So everybody go comment on Ava's little blip photo and just leave your comment and then vote on all of the comments by liking them. Your thumbs up like on their comment is your vote. So go on into the comment section and see what everybody else came up with. Yay! I am so happy you joined us. We have the best people from all over the world. I say it all the time. I've got my Canadian friends, my Scot friends, the Kiwis are here, the Aussies, of course the Americans. I've got almost all 50 states. I've got England and Germany and Belgium and I hope I'm not forgetting anybody. I have the UK. I have friends from all over the world, and we truly do. We have the best people right here. I'm not kidding you. And now you're one of us. Oh, I won't. I'll try. It's easy with you guys here. You guys are what make me smile. Hmm. Trying to think. You haven't really said anything particular that gives it away. I'm thinking Australia, perhaps. You get a standing ovation from CE. Love you, Sherry Bingo. Thank you so much for coming. Jenny Green, you slipped in at the end. Hello, sweetie. So good to have you here. We're just trying to figure out Jim Thompson's country of origin, as he calls it. I say Australia. Oh, but he's not. I'm wrong. Everybody will have to leave their guesses in the comments. I want everybody to guess, guys. They are the best. I'm so sorry. Woot woot. Everybody has to go check out and vote. All right, guys. Thank you again. Thank you so much for coming. You guys truly are the best. I love every one of you, and I'm so grateful and so blessed to have you as my friends. So I hope you all have a wonderful night. And for my friends across the ponds, have a wonderful day. Be safe, be well, sleep sweet, and much love.